Thanks everyone for joining us. This Financial Poise webinar, Post-Closing Issues, Integration of Potential Buyer and Seller Disputes, is part of the Private Company M&A Bootcamp for 2025 and is sponsored by Max Asset. Slide 6 of the PowerPoint summarizes this episode. Slides 7 and 8 summarize the series. Chatting about the slides and the PowerPoint, we're not going to be scrolling through the PowerPoint in any kind of order, nor are you going to have to listen to us regurgitate any of the slides. This webinar, like all Financial Poise webinars, is an informal conversation on the subject matter. You can keep the PowerPoint handy because we may indicate what slides our conversation touches upon. And if you're old school, like I am, you might have printed it out and you might want to take notes. Our panelists are, and we are joined today by John Levitsky. John is a partner at the global firm HKA, where he serves as a neutral arbitrator, independent advisor to the mediator, and expert witness in jury and bench trials, mediations, and arbitrations in the United States and internationally, including in M&A disputes regarding issues of valuation, GAAP and forensic accounting, and damages. Phil Buffington's with us today. Phil's a partner at Block & Bingham LLP, which is a full-service law firm located in the southeastern United States in Washington, D.C., where Phil represents financial institutions in a wide array of transactional and regulatory matters. Veteran panelist Michael Weiss is with us today. Michael is the principal of Weiss Burney LLC, which is a boutique corporate and real estate transactional law firm in the Chicago metropolitan area. As a transactional legal veteran, Michael represents privately and publicly held entities in business and commercial transactions and handles the negotiation and closing of complex and corporate and commercial real estate transactions, both domestically and internationally. He's also a certified public accountant, and his experience includes all aspects of M&A, securities, and corporate governance. Lastly, but certainly not leastly, is Jacqueline Brooks. Jackie is a corporate partner in the Baltimore office of Duane Morris LLP. Duane Morris is a national full-service law firm. Jackie concentrates her practice in general business and commercial law. She counsels clients in M&A, commercial finance, private placements, and corporate governance matters. Jackie has experience representing public companies, privately owned and family-owned companies, nonprofit organizations, and emerging companies. I'm your moderator, Robert London. I'm with Jasmine Schlesinger Narendran LLP, which is a full-service law firm in Garden City, which is just outside of Manhattan, New York City. My practice as a transactional attorney spans from M&A to startups to executive compensation matters to finance. Basically, anything that's fun to negotiate and tough to draft and vice versa is what I do. And I enjoy in so doing even after all these years. We're fascinating people. I'm sure you'd love to hear more about us and spend the whole hour learning about our practice and who we are, but I know you're not spending your time and money to hear our infomercials. If you're really interested in us, our bios are at the back of the PowerPoint. This webinar is a production of Financial Poise. More about Financial Poise can be learned on slide 40 of the PowerPoint deck. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand or listening to on demand, if you have any questions, you can send an email to info@financialpoise.com or actually look us up if you're so inclined at the back of the deck. Remember, the PowerPoint and conversation we're about to have are meant for general educational purposes and do not replace the need to consult with an attorney, accountant, and or other appropriate professional. In other words, if you take significant action based on something you hear today and things don't work out the way that you had hoped for, you've done a sort of silly thing, and please don't come knocking at our door, and you can forget that our bios are at the back of the deck. Once again, thanks again to our sponsor, Max Asset. All right, let's get this party started. I'm going to start by inviting Michael to identify just one post-closing occurrence that arose, which was completely anticipated by the parties in the deal, and tell us all about it. And then I'll follow up with him a little bit on that topic once he regales us with a fun war story.
Good afternoon, everyone. Pleasure to join everybody this afternoon at our webinar. I have a lot of examples of post-closing occurrences that were unanticipated by the parties to a transaction. It happens a lot, and you'll hear from others here too in all sorts of different ways. But one that jumps out at me was probably about 15 years ago, representing the buyer to a transaction. Um, Buyer's private equity group, portfolio platform company, and a lot of due diligence, very thorough agreement. Um, there was one issue which really wasn't talked about much during the deal, a little bit of a problem with customer concentration, meaning a lot of the business was really focused on maybe 8 customers. And what happened about 90 days after the closing, all's going well, is when our client, who was the buyer, gets notice from a customer that this customer represented 20 to 25% of the revenue, not insignificant at all. That this customer would no longer be using our client's business. Our client manufactured widgets. Let's just say this was a shock to our client, and the seller really had no idea and claimed they had no notice. But there was a lot of unhappiness because it changed the what would have been the pricing of the deal and the terms of the deal, completely unanticipated by the parties. Although I think we in the M&A world find that if something's completely unanticipated, there's sometimes some allegations back and forth. Well, was it really unanticipated, or did someone know or suspect something? But this one was relatively unanticipated.
And it was unanticipated, putting the Wayback Machine on. What could have the parties done to either anticipate it, or how was it resolved?
Well, it's a great question, Robert, with a great resolution. 80% of the purchase price was cash, and there was an earnout element of about 20%. And the seller was a very honorable person who never, there's the typical reps and warranties in the document. Here's our 15 best customers. You don't notice of any intention to lose this customer, and so forth. But there were some discussions going up and back as to whether someone really knew, because it got traced that a low level employee of the company may have heard something hearsay from a lower level person at this customer that they were looking at different options. But in business, you hear that all the time. So there were some, I don't want to call them threats, but there was some tension for a while. And actually, although not really obligated to do it, this was sort of surprising. The seller agreed to a price change and a price reduction on the earnout portion. And it turned out the parties agreed, they signed off on a change, and the business went on to thrive. So that's one situation where something negative and unfortunate turned into a plus. And the seller was actually happy. They had sold the business at a high multiple, and taking a little reduction at the end of the day was not that material. So all's well that ends well. I think the lesson, the takeaway, love to hear what others have to say, is you just can't anticipate everything, and the document doesn't necessarily cover everything. And hopefully the parties will use some common sense and fill in the gaps with some commercial reasonableness. And we
Oh,
did in this
that's
case.
that's a nice segue, because now I can ask Phil. Um, Maybe he can describe a situation where something popped up post closing, but it was actually anticipated, and to what extent that anticipation was reflected in the documentation and was effective.
Robert, the one instance, I mean, I've had several instances, but one that jumped out in my mind was where I had a seller that had an affiliate that was providing services to the seller. And as we worked through the transaction, both the seller and the affiliate had different presidents. So along the way, the affiliate got sideways with the purchaser, but after closing, the affiliate's president started to try to assert themselves. But what we had done is include a transition services agreement as part of the purchase documentation. So the terms were really set out on what was going to actually happen. And because of that planning, it avoided a major catastrophe because the affiliate was providing a service that could not be provided by anybody else for about 9 to 12 months. So it was essential. And if we had not planned on that, there would have been major problems and probably an even more significant price adjustment than Michael experienced there. But again, the importance is really thinking through what you can and planning on it. And that transition services agreement for us made a huge difference in that transaction.
Anything else you want to add to that? Like, let's sort of take half of Michael's response and throw it into there. Like, that's how you handled and thought about it. And that's what happened. What else, what would have been the cherry on the sundae, perhaps?
In that instance, I'm not really sure there could have been because there were personalities involved.
Mhm.
The seller would have been willing to make some concessions, and the problem really was with the affiliate president who wasn't willing to make those concessions because certain things didn't happen for the affiliate company that he wanted to happen in the transaction. So I guess what we could have done is planned a little bit better and anticipated his obstinance. But again, it came out of the blue.
Okay, I can live with that. When I have Sundays ice cream, I don't put a cherry on, so it's okay.
Yeah, I gave you whipped cream, but I just couldn't give you the
Okay,
cherry.
all right. I kind of like that chocolate syrup and the marshmallow sauce too. I like that. But let's move on to John. Uh, let's talk about integration, post-closing integration. When's the best time, and when do you typically advise principals to start planning for post-closing integration of the acquired companies, John?
Well, what I see in the marketplace, I see that early is usually preferred. Early in the process, obviously, want to plan. In most cases, I see pre-close, sometimes during the due diligence process, sometimes perhaps even a little earlier when they're starting to contemplate about whether they may have a serious interest in certain candidate companies. And part of that thought process is to think through why are they contemplating possibly making this acquisition or merger? What are they expecting the benefits will be? And what sort of incremental valuation model are they developing? And what might be the key assets and business plan if the companies were combined, and to think about an integration plan, at least at a high level early on, that might achieve those sorts of value adds that they're expecting as a benefit of the deal.
Okay. Let's hear from Jackie. What are some of the common pitfalls that you see in the process of integration, and might be some good ways to mitigate both either in advance or during integration?
Yeah, I think, a lot of the common pitfalls are often going to be related to people, and likely the synergies that were being anticipated by the buyer, which encouraged them to buy the business. Some of which I think we've talked about, especially with regards to, for instance, what Phil was saying, when it comes to sort of cultural clashes or people clashes. Oftentimes there are issues that may come into play when there are conflicting systems, loss of key talent, and then overall sort of inadequate planning. And so in order to mitigate these, I think in addition to, which we always encourage any buyer to do when they're looking to buy a business, is to do a thorough due diligence. But when you're doing that due diligence, really think about what you want the company to look like post-closing, so that you are creating an integration plan prior to closing, that you're able to sort of, take action with quickly, making sure that you do have a dedicated integration team. And especially if you're combining two different cultures, ensuring that integration team has representation from both sides, that can figure out how to, create whatever the new culture will be going forward. And also planning and thinking about how you're going to retain the key talent that you have there, whether that's incentive plans, compensation, etc. I think all of those things really have to be thought through. And then the last thing I would say, especially if it's a business where you're relying on specific customers, ensuring you understand those customers, what those customers like, so that you don't have a situation that Michael talked about, where you may lose a client that represents 25% of the business.
All right, so let's throw this out to the group sort of by, survey. I find two things happen, and it's sort of digital. It's either a 0 or 1. I have a seller that absolutely refuses to let anyone know about the deal other than the super senior management that's needed to help fire due diligence until literally the eve of the closing, where, short of the closing call where wires are sent. And then I have others that perhaps sometimes where there's an earnout involved, or there's roll in equity, where early on the cat's out of the bag that the deal's going to close, but there's a focus on significant employee retention. What's everyone's experience? I'll start with Michael. Which do you happen to see more of? Just out of, there's no right or wrong, there's no prevailing trend. Just out of curiosity for those people who are listening and considering at home.
Great question. Very important topic at all times. In my experience, it often depends on the industry. And also in my experience, a couple things come to mind. And Jackie really was right on the money. Businesses ultimately are people. Even in a manufacturing company, you need salespeople, you need management people. So, from a buyer standpoint, a buyer often wants to be sure when they take over a company, the important people, for lack of a better term, are going to stay. And there's often, and as a seller, I really understand that. And if I want to get to the closing, I'm going to allow some sort of necessary communication, especially in a business where individuals are very responsible directly for sales or indirectly for the sales element. If the products don't sell themselves, either on a website or something else, if a key salesperson is going to leave, we won't get into whether they have a non-compete or not. That's going to change the deal. So I do see discussion in every deal about who should be understand that there's a deal going on or that there isn't. And then the flip side of the coin is sellers, to your example, Robert, often don't want the cat to be out of the bag because if they know the company's for sale, people tend to scatter even before thinking, "Oh, I'm going to get laid off or I'm going to get cut." So there's some up and back, understanding a buyer's need to know if key people will be there post closing and under what terms, and a seller who's nervous if the cat gets out of a bag and people could sabotage a deal or not close a deal. I've really found it depends on the industry. But I will say generally in my world, the more the key people, the more important they are to the business, a buyer's going to want to talk to them and going to know that they're going to be there. Lower level employees, and that's defined differently for every company, maybe not so much.
Okay. Phil, your world?
Yeah, Robert, I agree with everything Jackie and Michael and John have said. I do think it's important, and regardless of what the seller or buyer are trying to do, communication is essential for post-merger integration. And so I adhere to the philosophy that you do it early, you do it often, and you try to be transparent with what's going on to the extent you can. One way that I found to help do that is to form a committee early on that's focusing on post-merger integration, where that's part of your job. And it's part of your job from the beginning all the way through the closing, where you're looking at those issues and it is your true focus. So I found that to be helpful, in particular in financial institutions.
Okay. John, round us out. No cherry on the sundae. Let's just stick with the ice cream.
Well, I concur with says it sounds like we're saying it's facts and circumstances
Mhm.
oriented, and I concur, and that's what I see in the marketplace. And I go back to what I said a little bit ago about why is the deal being done and what's expected to drive the incremental value once the business combination occurs. And so, who are those people that you expect are going to be there after the business combination? And why are they going to stay? And are their goals aligned with whatever the goals are of the combined entity post close? And so in those situations, would seem that the buyer is going to be more motivated to want to talk to those people and perhaps make some deals with those people pre-close. And so I've seen that several times in real world transactions. I've also seen occasionally, we didn't get into problems, but I've also seen, despite everything that I just mentioned happening and equity arrangements made with certain key people to encourage them to stay, some of them went and violated the employment agreements and jumped to a competitor a month after the close. But there is a motivation on the part of the buyers to want to have some comfort level that what is expected to drive the success of the deal is actually transferring.
This might be ripe for like the completed key provisions of M&A contracts. But so in the employment agreement where you give equity, would you recommend, or how prevalent have you seen like a haircut or a discounted repurchase or forfeiture of equity if you violate a restrictive covenant? Because we all know now non-competes related to employment are pretty much unenforceable these days. They have to be tied to either to some additional benefit or equity. Like, when do you, how often do you see that now? Are people moving over to that? Because in a simple services agreement, you really just can't lock up anyone post termination, regardless of the circumstances of the termination.
Or there may
Um,
be some vesting period. In other words, if they don't stay for a certain number of months afterwards, they don't get fully vested in that additional equity.
So let's say they're vested, but then they, during that period of time, they were either self-dealing or committing fraud, or even after that vesting period, and they've been with the company, let's say for 2 years, and they vested 2/3 of their equity, but now they leave to compete. Do you see a recapture of their equity, or is the more executive friendly negotiation, like if I'm representing the executive and I'll make an argument that, hey, come sue me for some sort of damages, but I earned my equity, it's mine, and if you want it back, it's fair market value.
Well, I'm going to defer to the practicing lawyers on the panel, but what I see in the marketplace is a variety of potential litigation claims being raised, depending on the jurisdiction and depending on the agreement. So I'll defer to the others that are practicing lawyers.
yeah,
Anyone else want to jump down the rabbit hole that I
sure.
just dug with my own shovel?
Yeah, I will jump in. I am seeing lately, and curious to hear from Jackie and or Phil. I am seeing company-friendly equity agreements um, totally over the last, I don't know, X number of years, unless some employee really brings something very, very valuable to the table, is a superstar. The run-of-the-mill executives, and I know what is a run-of-the-mill executives, um, your typical equity agreements, there's vesting periods, as John mentioned. There's thresholds in terms of liquidation events. There's forfeiture for, fraud, gross negligence. I mean, it's really an uphill battle for the employee to come out on top, unless they're negotiated or they try to negotiate it. And then often the company is coming back and saying, well, we can't negotiate these, or we would have to be negotiating them. Boils down to the leverage. If you're really a key employee, that's the time to get your world of compensation package. That's your bite at the apple. But I am seeing those documents very company friendly.
Yeah, no, I agree. I think many times there will be forfeiture provisions, but depending on the negotiating leverage that the employee may have, how that forfeiture happens, whether it's a complete forfeiture or it's sort of a right of the company to buy it back at a heavily discounted rate. I think companies, based on the litigation that John mentioned that's happening, you do have to make sure that there is still sufficient consideration that was given to the employee in whatever form that's put in the agreement for the restrictive covenants that we're expecting them to abide by.
Okay, well,
And
this,
if I could just add,
please.
sometimes I see in the marketplace where the equity agreements are written such that it's like a preferred stock with a stated rate of return. And unless the individual leaves the company under very specific ideal circumstances, ideal as the company would define them, then it doesn't convert to common equity. So the upside to the investment is relatively limited unless the ideal circumstances occur.
So I haven't seen that. I like that. I want to put that in my bag of tricks. Um, all right, let's this is sort of a doomsday episode because we're dealing with disputes and bad things. So as far as bad things go, we'll talk about post-closing losses and occurrences. Something bad happens there comes to light after closing. Michael, how do you plan for those? How might a buyer assess existing insurance coverage to see if it might be useful for post-closing claims and to fill in any gaps of insurance that come up during diligence investigation of the insurance? Is M&A insurance a real thing? Is getting tail coverage workable? Is that a thing?
Yeah, a few comments. First, with regard to insurance generally, um, uh, I think it's important as part of the deal team, that the buyer side and sometimes the seller side too, but we'll um, kind of focusing on the buyer side now, really have an insurance professional. I know the M&A lawyers on the panel, we are absolutely not insurance experts. And one of the, in addition to your tax expert and your many other experts, I always insist that clients have insurance experts. Different industries are treated different ways. There's different exposures. So just for, product liability, uh, employee claims, injury, other words. I love to have an insurance expert really um, pour through the existing coverage, what the tail are. We'll talk about rep and warranty and insurance in a second, and really advise us on the buyer's side where we're covered or where we're not. And if we're not, always depending on the industry, love to get a big holdback that will last for as long as I can get it when I'm a buyer. So there is some financial pot of gold, if you will, whether it's insurance coverage or cash to cover things that come up post closing. The last thing anyone wants is litigation, where unfortunately we get into litigation, but litigation is very expensive. So I really call in an insurance expert. It really depends on the type of business in the industry because sometimes if you're making products, of course, and there could be product liability, that's one thing, but there's usually some type of exposure out there. Rep and warranty insurance, turning to that for a moment, is still relatively new. There's not a lot of cases, and it only works in deal size of a certain range because it's very time consuming, very expensive, but it puts more money in the seller's pocket to have an insurance policy cover items instead of holding back money. Um, and it often works out good. And the private equities seem to like it and seem to be adopting it. My biggest concern about rep and warranty insurance, and I'm sure everybody on this call will agree, it just hasn't been around that long, and there's not that many cases. So we're, I think, still in a learning period in the M&A world as to how it's all going to work. It's a heavy underwriting, and there's a lot of exclusions. And I think at the end of the day, sometimes I'm a little bit disappointed that there's more exclusions than the exceptions sort of take care of the general rule that there's coverage. The way to plan is from a buy side, a hold for as long as you can get it, as long as the seller will allow negotiated terms. Really thorough, knowledgeable insurance with a real astute insurance advisor, and rep and warranty insurance if it makes sense. Again, there's going to be a lot of exceptions. I would add a third thing. I would, and I've written articles on this, due diligence. I see, and to go off topic a little bit, I see a lot of buyer claims often, and I may be representing the buyer too, were preventable or avoidable if the buyer had only paid attention to what they were, the due diligence process, and brought up the issue. As the lawyer professionals, Phil and Jackie and John in the world, we're not in their office every day combing through all the documents. So our clients have to do the work to prevent what's preventable.
And
Oh.
and if I could add about due diligence and insurance, buyers make the decision as to how much risk to take on. And sometimes buyers will proactively make a decision to move forward without evaluating all the risks or without undertaking as much due diligence as perhaps some other uh, parties would, because they are motivated to get a particular deal done. There's an overall strategy that maybe they're pursuing. Maybe they think they just need to do the deal. They want to take the chance. They understand there's risks here, but if it's going to make them number two or number one in their marketplace, they do this deal. Maybe there's a motivation like that behind the scenes. So there's no such thing as the same due diligence in every deal, or the same insurance or risk profile. The buyer's making that decision, but what we're talking about is examples for both buyers and sellers to learn from, and then maybe they can make a more informed decision when they're weighing the risks and how much depth to go into before they make a decision.
Yeah, and Robert, to play off what John's saying there, just so everybody fully understands this, due diligence that one of the five of us may do at a high level can be very costly. And sometimes a buyer is not willing to do that because of the risk, and they're willing to assume some of the risk, like John said. But that's a real key ingredient that I see in due diligence, is how much cost people are willing to incur to accomplish what you're trying to accomplish in due diligence.
Is an insurer's due diligence process in looking at the potential risk any different from a buyer's, or is it just sort of offloaded and figured into what the premium is going to be?
I think it's a mix.
Yeah.
Of that. So a buyer's due diligence, if they've done a really good job, then they will have less exclusions and will make the underwriting process with the reps and warranties insurer go much, much more smoothly than if they did not do a full due diligence process. Because essentially what the insurer is going to require is for there to be full on due diligence. And if there's something that's not covered, they're just going to exclude it. And so, I think Phil is right that when you're looking at doing a transaction and potentially getting that reps and warranties policy, you're going to have to sort of include that cost of exhaustive due diligence to make sure that it's worth it.
So I'm going to stick with you, Jackie. So we have rep and warranty insurance on our deal, and now there's a dispute. How does the dispute process play out with the insurer? And as a buyer, like, hey, do I still get to sue the seller because I have an indemnity claim too? Are they exclusive? How do they mesh? What actually happens?
Oh, I love to give my favorite answer. It depends.
Great.
So it depends on how it's structured. If you are a seller that's lucky, maybe you actually ended up with a deal where it's what I would call a walkaway deal. So it's reps and warranties insured. Any indemnification claim, the buyer will solely look to the insurance policy and not to you. When you get reps and warranties insurance, there is, for virtually all of the policies, there's going to be some sort of deductible or retention amount. And so what that is an amount of claims or claims that the buyer will have to incur and cover before the insurance policy sort of kicks in. And so as the buyer, you have the ability to structure this where the seller is required to cover that directly, whether that's placed in an escrow, a holdback, etc. The buyer can also, especially if they're, bidding against other buyers and really want the company to say that the buyer will solely cover it. And so in those situations, the seller, if it's a walkaway deal and they're not covering any deductible or retention amounts, then the buyer solely looks to the insurer. They will need to make a claim to the insurer as soon as possible. And even if the seller is supposed to cover some of that, you still want to make a claim as soon as possible because you need to be able to aggregate what the loss amount is for you to be able to then get coverage for that. Unlike some insurance policies, in other situations where you have to use the insurer's counsel, the nice thing about reps and warranties insurance is most of the time the buyer gets to use the counsel that they used on a transaction if there is an indemnification claim. And those amounts are usually also covered under the policy. I would say if you are a company that is selling to a private equity-backed buyer, what I've seen over the past year is that, especially with private equity-backed buyers, they have a lot of access to a lot of insurers that are competing for this reps and warranties insurance policies. Some of the prices have gone down, and a lot of the policies in those instances are actually even covering what we would consider, which I know we've covered on the key provisions, fundamental reps and warranties. And so, this is definitely something that you want to look into.
Great. Let's shift away from insurance for a while. Let's sort of go to some more macro substantive areas of integration. John, what are some of the concerns with each of, after you perhaps chat and identify the main substantive issues? Let's make it your top 3, top 4 areas of integration that have to be addressed, and what are some of the concerns?
Well, the big picture, I first go back to what is it that w- is the motivation for the deal? Are we getting the key assets? Are they being transferred? Is there a transition plan? And does that align with how we determined what the incremental value of this deal is expected to be to our combined entity? And then we start benchmarking and put some KPIs in place along that line. But some of the key things that can become problems fall into those classic areas of what are the key assets. We already heard about key customers can be an issue that perhaps they don't transfer well. We heard about transition services plans, lots of time. These acquisitions are essentially spin-offs or carve-outs of other companies, uh, or they are a company that their system needs to be changed and upgraded even without an integration. And a lot of times from a IT and an infrastructure perspective, that technological infrastructure transition plan is not sufficient. There's lots of noise, lots of friction, and you may have a very viable business model that just can't operate well because the IT hasn't been really planned out to see whether it's usable and in transition. If you want a glaring example of that, about 20 years ago, Sprint and Nextel merged. They thought they were going to become this super giant mobile phone company. And what happened? Nextel system and Sprint system, their mobile phone systems didn't talk to each other. They couldn't combine. That wasn't thought through well. The technology that Nextel had was becoming obsolete in the marketplace. I'm talking about their actual service delivery technology. And then their infrastructure, like to do billing together or interpersonally for their people to work together, they had cultural and systems problems. It really wasn't a natural arrangement, despite all the planning you'd want to do. You can't plan for the technology becoming obsolete and the marketplace moving ahead of your key acquisition merger target you just combined with, and the cultures and the systems just not naturally going to function well together. Branding's another issue. What are you going to call the company? And again, why are you doing the deal? You want a glaring example of where problems arose? Quaker Oats bought Snapple in the 1990s. We all know Snapple. It's a popular beverage, but they bought it. They thought they could scale it, but they didn't understand the business well enough to know that why Snapple was popular. Snapple had kind of an offbeat, sort of esoteric, fashionable following. Taking it and trying to scale it like Gatorade, which was a Quaker Oats product as well that was very successful, didn't work well. They paid almost $2 billion for the deal. Their marketing and branding was way off. They completely changed the marketing. The market didn't understand it. 2 years later, they sold the business for just a few $100 million. Uh, Risk management and compliance. We talked about some of the potential legal things that you may encounter or compliance issues and personnel continuity. A glaring example. We've all heard of Kentucky Fried Chicken, and I think everybody on this call probably knows who Colonel Sanders was or is. They even have new fake versions of people emulating Colonel Sanders. Would you believe when the company was acquired back in the 1960s, they did not have Colonel Sanders under contract? Could you imagine what would have happened if he'd gone to work for McDonald's? Uh, they eventually figured that out and got him into consulting contract mode. But having your personnel is important. We talked about that earlier. But is there someone that is the face of your business? And do you have that person not only under contract, but is that person going to be a good representative? We also all remember uh, Subway, and they had Jared. He was a very popular spokesperson. Now, he wasn't the founder like Colonel Sanders was of Kentucky Fried Chicken, but eventually some things came out about Jared's personal issues, and suddenly he's no longer the spokesperson. So you not only want to have the right personnel in place, you want to have the continuity. but you also need to be able to manage risks in a proactive way. If you do have a Jared situation, or if you had Prince Andrew wasn't a spokesman, but if Prince Andrew was a representative, that could be an issue too. So you have things you want to manage through, so that basically we're talking about, you want to realize the business model, the combined business model that you were anticipating when you did the valuation and made the pricing decision, and remove the noise and try to minimize the risks that are avoidable in trying to achieve that.
So it looks like one of the lessons is consistent with one of our themes here, which is also due diligence, which means go look at Colonel Sanders' browser history, right? You know. All right, let's keep it going. And we're still, we talk, for the most part, this is private company boot camp, which typically means, at least in our worlds, smaller mid-market. In many of those deals, the sell side is exiting from the business because there isn't, it's a family business, there isn't a next generation, or maybe they're going to start a new venture. And I haven't heard from Phil for a while, so I'll tap Phil. Let's put on our buyer's hat, Phil. As a buyer, how might you be concerned with exiting shareholders and owners, and how might you try to protect yourself, and maybe flesh out some of the things we've already chatted about, it all into one succinct little sundae that we can put a cherry on?
Well, I will certainly try to do that for you, Robert. I think we've touched on a lot of this. There's obviously a lot of concerns if the seller's walking away. And I think the first one would be, the biggest concern to me is if the seller's real objective is to take the cash and disappear, then I have to be worried about everything, about whether or not the agreement is really as tight as it should be. But backing up from that, if the seller is really saying they're retiring, my concerns would be the age of the seller, whether or not they were really an entrepreneurial spirit, whether or not they were going to go out and try to start a new business, whether or not it could compete directly or indirectly with the business they're selling to me. This leads to a lot of questions along the lines of, am I going to be able to retain the employees? Will the culture fit with new ownership? If I've got a competitor out there by the seller starting to compete with me in any form or fashion, and whether or not the personal relationships, getting back to Michael's comment about customers, whether or not they've got a personal relationship with the seller, that they would follow them in some transition to a different type business. With everything that's going on in business today, and with so many transitions, those would be some of my concerns. Some of the ways to protect that obviously is in the agreement with the reps and warranties. We've spent a tremendous amount of time on that. Having an escrow agreement as a paying out over a period of time through an earnout, having some restrictive covenants, and not necessarily so much a non-compete, even though I don't give up completely on non-competes, but at least a non-solicitation or a confidentiality agreement. So really, they're not going to be competing for the same customers, for the same type business that I think is still there. And then some mechanism by which the buyer can hold back the ultimate cash payout to the seller over a period of time to ensure the transition of the business to the purchaser. I think any purchaser is going to want to have the ability to have that transition time. And if they don't think they can run the business, then they're going to be concerned about it for a longer period of time. But if they think they're going to be successful with their purchase and they've got a plan, then they probably have an identified period of time that they just don't want that person in-house really competing with them. So I think that would dictate some of the timeframes that we're talking about here. That's at a high level. The cherry would be is, you don't have to, you have some owner financing there where you've always got the owner on the hook until the very end.
Great. So the theme of this one is disputes, and typically disputes are about money. It's rare that you see a post-closing dispute because someone doesn't like the way they rebranded the logo or something like that. So let's stick with the money. Many deals close, let's say, on an estimated net working capital adjustment. how much money is in the till to keep the lights on when you close, what the spend rate has been going in and after the deal. I'll tap Michael. Can you describe the closing mechanic on how net working capital adjustments are done and how disputes arise and how typically they are resolved, whether either within the four corners of your agreement or otherwise?
Sure. And just to back up a little bit, what is, for our audience, what is a working capital and a working capital adjustment? When you're a buyer buying a business, it could be structured as an equity deal or an asset deal. You're expecting um, X amount of working capital in the business to keep the lights going. It depends, though. Everything's negotiable, but typically that's the way businesses are bought and sold. And it's great from a buyer standpoint because it's money they don't have to come up with either in debt or equity in order to um, start the business with some capital, but not always. Every deal is different. Every industry has sort of district, but in a net working capital, the buyer and the seller will agree on a target and will say, okay, at closing, hypothetically, let's look at past, and we see, it's a seasonal business, it goes up and down. Let's do our calculations, and we should have hypothetically $1 million of closing. So very often, and that target is maybe picked out 2 months before closing. Sometimes it's being modified right up until the date of closing into the agreement. And then a count is sort of done and estimated at closing. And there's a true up, the working capital adjustment, 60 days, 90 days, 120 days later. And it's really a accounting function. And why does it take time? Well, what is working capital? Current assets minus current liabilities. It takes a while to figure out what your cash is, what your receivables. I'm sorry, put cash out of the equation. Your receivables and what your payables, because payable come in, there's accruals and all sort of accounting machinations. So there is often, 90 days after closing, everyone will know what the true working capital was at closing. And very often parties will set aside a pool of money in case from a seller's proceeds, in case the seller owes the buyer money. Or sometimes it goes the other way. And there is calculations done, and the parties will do, accountants may talk to accountants, and they'll come up with, yes, we agree, or we don't agree that this was the working capital and this was the adjustment. Okay, we agreed on $1 million at closing, but we did all the calculations. It was only 800,000. So
I'm gonna
seller,
stop you there because we're starting to run a little out of time, and I definitely want to
yep,
tap John and Phil because earnouts are such an
yep,
important part, and there's such a period of
let's do it.
disputes on earnouts. And I think networking capital adjustments. Maybe I'll just beef up the key provisions episode. John, briefly, and leaving some time for Phil to close us out. What are some of the things that the parties have to keep in mind after the closing on earnouts? And then Phil, if you'll close us out after that, what are some of the things that the sell side should definitely negotiate in earnouts? So, John, please take us away, and Phil finish us
Well,
off.
an earn-out is contingent additional purchase price pursuant to the acquisition or merger agreement. And some of the key issues are who's responsible for achieving the earn-out, who's responsible for doing the calculation, and what's the methodology of the calculation. And then within the calculation, what are the key variables? And has there been adequate tracking of those, and has there been any undue influence that might not be in compliance with the agreement? So The ability to measure performance, should the business activity be kept separate? Or at least is there a way to track the activity that's captured under the earnout agreement? What happens if there are other dispositions, acquisitions of other businesses after the close? Or what if the management decides to expend resources in other lines of business and make some business decisions that may not be as favorable to the part that's supposed to be measured for the earnout? Are there some offsets? And then the good faith covenant of a buyer, that's going to vary by state. That depends what's on the agreement. In other words, Texas law and Illinois law and New York law are not all the same. There are some legal issues here to keep in mind as well.
Okay. Bill?
Yeah, I agree with what John's saying. I mean, the big issues would be operating the business in good faith, making sure that there was some consistency with some of the past practices. Because again, if you're going to modify the way the business is operated, ultimately that could affect the bottom line. I think you've got to look at whether or not you want to try to have some approval rights if they're going to be major changes. And last but not least is access to the books and records for purposes of the earnout. I think those are four very important issues that you need to address.
Has anyone ever seen, and I'll start with Jackie to finish this topic off. Have you ever seen a buyer commitment to a budget to grow the earnout? I mean, I've seen that and have gotten it a few times. Has anyone else on the panel seen that in an earnout?
I've seen it a couple times where they've committed to a budget. I've also seen certain situations where the seller was able to get the buyer to agree that if certain things happened, such as an acquisition, etc., that it's deemed earned, and we're done. But I think having a budget and having to actually comply with that, I think, is helpful. Because usually the good faith covenant is often broad, and hard to, say what was a good faith effort done.
Okay. I'll stick with you now that I have you, Jackie. What other types of other net working capital adjustments and earnout negotiations? What are some other potential adjustments and things that might arise in an M&A deal?
Yeah, a lot of things are going to depend on sort of balance sheet items. You can have accounts receivable adjustments, inventory adjustments, especially if it's a manufacturing business. There can be adjustments made with respect to net worth or asset value, depending on the type of business it is, as well as EBITDA is some of the things that can be done. And we've been talking about earnouts, and earnouts can be based on all those things as well. EBITDA, revenue, profits, losses, as long as it's actually the target is well documented and there's an agreement how to calculate it.
Okay. How about, since I made sure we got to earnouts and I interrupted Michael. Michael, anything you want to add either on earnouts or anything else before I close the webinar out?
I just a couple comments on earnouts. I think Phil, Jackie, and John would agree. Whenever there's an earnout, and I'm involved in a lot of earnouts, there's always a dispute down the road. You could spend 30 pages drafting it, and someone will that's why sellers love cash deals, and buyers sometimes like cash deals at a lower price. And I would just get back to it's still a lot of earnouts, but it seems in my world there's always somebody's pointing the finger about somebody's not trying hard enough or the milestones weren't realistic. But anyways, on net working capital adjustments, no, just very, very accountant driven, always some discussion kind of at the end. And usually it gets resolved when the accountants agree and put their pencils down and say, we agree on the numbers.
Great. Thanks, everyone. I mean, I caution both buyers and sellers on earnouts, which is whether or not it's worth it to think of a cash number, given the legal spend on negotiating them. I mean, yes, lawyers' cherries are expensive, and welcome to negotiate a long earn out provision if you want, but really make that consideration and thought up front. Thanks again, everyone. This has been a great one. I don't know if we should be allowed to have so much fun. Thanks again to our sponsor, Max Asset. Please join me on December 9 for episode 5 of the 2025 M&A Bootcamp entitled Negotiating an M&A Deal. Until then, have fun and stay well. Thanks again, everyone.
Thank you. Bye-bye.
I all.
Thank you.